Hi, I'm Jack Gatlin, and welcome to Beyond the Bar with Jack and Brandon.
Hey, we're here for our weekly podcast / video cast to talk about employment law, stuff that we see as an office, stuff we hear, especially this time of year at cocktail parties and whatnot. Jack and I are joined today by Tony Bucher. I think it was about 2 years ago this time, had the big killing case out in Boone County. It was a $2 million verdict, I think, wasn't it, Tony? About Christmas 2 years ago?
December of 21, actually, 3 years ago. But yeah, it was a good one.
And that case finally survived all the way to the Supreme Court, and it was the full $2 million verdict with interest was affirmed, about 4 to 6 months ago?
Yep. Late August, mid-August, yep.
So that pretty much proves when we tell people that the appeal can take just as long as a trial, if not more, that we're not lying when we say that.
It's not for the faint of heart. It's
No.
to go the long haul. You gotta be prepared to stick it out. So it was very happy for the client. He got a good result, and he was very patient, and good for him.
You know, I never really paid a whole lot of attention about when they changed the judgment interest rate from 12 to 6. But when your law partner pops a $2 million verdict, maybe you should have called my legislature when they were changing that from 12 to 6.
6% saved you a buck or two, didn't it?
Now it was lower than a 30-year mortgage rate.
There you go. Yeah.
So I guess what we want to do is kind of just talk about, we get a couple calls a day about employment cases.
I'd say about 10. What do you say, Tony?
It varies, obviously. It depends on time of year is a little bit of an issue and everything else. But yeah, we can get anywhere from 2 or 3 a day to as many as 10. So it's obviously an issue that people are dealing with. People are dealing with those issues all the time.
So let's talk about some of the oddball calls, because I do think in the employment law world, we are and when I say we, I use the term we as a firm, because you are the brains behind the operation for employment law here right now. You obviously have a team with you. We have arguably 2.5 to 3.5 lawyers that are almost exclusively doing employment law right now.
That's a good guesstimate. That's the way I put it.
So, without obviously naming names, I do think that some of at least the emails that I receive are humorous. Can you think of some of the more just humorous, and I don't mean to be making fun of people. I think what we want to stay is within the confines of, this is not really grounds to sue your employer.
Right. So, and obviously, like you said, being fired is obviously a very traumatic experience for anyone. So when that comes up, I think a lot of people are confused and looking for answers, and they just, nobody believes they deserve it. So yeah, they'll call with any number of reasons, and I think it's always some of the most oddball ones, or somebody will call and say, hey, I've been late to work the last 5 days and they fired me. How could they possibly do that? And you're like, well, you so unfortunately you can't help those folks.
Right.
You do have to go to work. It's not an entitlement. You got to put in the effort, and you got to follow the rules, But it goes from those, the ones that you're curious as to why they even called, to the ones where you obviously you see something wrong and you like to help those folks.
What do you see as far as themes of some of the more common things that employers screw up?
I think screwing up is, I think, when you allow a manager who has been called out by an employee make an ultimate decision on that particular employee, right? I mean, because nobody likes to be called out. So if you're calling out your manager and they get ticked off and decide to go ahead and let you go, sometimes they're not allowed to do that. So
It becomes emotional.
yes,
right?
absolutely.
When
Absolutely.
management makes decisions based on emotion instead of just following the law, being logical.
Absolutely, you're heading down the wrong path for sure.
In fact, you had another pretty good verdict a couple of years ago involving a case that I think even hit a lot of the talk shows throughout the nation. It was the birthday case, and I don't know how much you want to go into that case, but I think what was interesting about that case is I think the jury gave a very, my just as a layman, a lawyer that sort of saw that case from afar, the jury seemed to be punishing the employer or a manager because of maybe an emotional response to an individual who had a mental health issue.
Yeah, it did get the moniker of the birthday party case or whatever. It did draw a lot of.
And folks can Google it if they want to know a lot of the facts. Just Google birthday party case.
And it really wasn't about
County.
the birthday party too much, but it really was, like you've said, it was about a manager who overreacted to a mental health issue and ended up letting the guy go, who was, every time I think of the young man that was involved in that case, I just think he would be an ideal employee. Mm-hmm. And that's something, when we're talking to folks, that's something you get a feel for, immediately in that first half hour you meet with him. You see, is this the kind of guy that I would want working for me? And if it is, then you start questioning why these employers decided to go, to let him go.
That's right.
So,
because at the end of the day, I think all cases, once you agree, Brandon, are, the law gets you to a jury.
Yeah, you got to survive summary judgment. That's,
right. So the law, that's a
hurdle.
critical thing. But once you get there, it really just becomes a likability contest.
I think that's true of a lot of trials, but I think even more so in employment law.
That's right, because I think
salt of the earth. Judge Stein used to always tell me a good plaintiff that there was a case years ago. I wasn't my case, but jury had given big damages, and I remember Judge Stein referred to the plaintiff as a salt of the earth type person. And I think jurors, they think you're a good person, they like you. I think that's the way they show that. They hammer the defendant.
Yeah, I think that goes both ways. I think that goes for the plaintiff and the defendant. I do think it is, like you said, with juries, people always tell us you can flip a coin when you walk into there for that jury trial, because you have no idea how it's going to come out. But if you've got a client that is likable and presents well and to a jury, then their chances go up for sure.
So let's get into some sort of sticky issues, right?
I think that, we were talking about it beforehand. I think that especially the world is different. Well, first of all, you have so many people working remotely. So it's like when they actually are on site, they have to interact with each other. And, even in today's whole, people being canceled or woke or whatever, we all know, we've seen the examples of you got people that, it's coworkers are out to lunch and maybe one of them starts talking about their good or bad sex life at home or something. Tony, how, everybody's going to sit there. We all will be, again, at a cocktail party time of year, be like, well, I just happened to mention that I was having an affair with my wife, I'm being sued for sexual harassment or something. How does it, obviously we know that's not true, but people have this perception that if you talk about anything that's kind of controversial, somehow you're going to be subject to a sexual harassment or other type of suit. What are some of the stuff that you're seeing that happens in an employment setting that it isn't actionable, but people think it really is?
Well, it's like you said, is if you're talking about that, I went on a date this weekend and I really liked this girl and we made out in the car for a while, and people get their, people start acting like they've said something terribly inappropriate, and maybe, sure, it's probably not appropriate for the workplace, but as far as being, World War III lawsuit, I don't think that's necessarily true.
But it all goes to hostile work environment, right? So is there a defined standard for hostile work environment?
It's hostile work environment. The law is pretty clear. It's not a single statement or a single comment or a couple of missteps here and there. Hostile becomes something where it becomes something that's happening over and over and over again, or somebody who doesn't seem to be able to catch on. But I hit on one of your points, Brandon, just briefly is you sort of alluded to it, but I think the problem today is old man guy here complaining about phones and technology, but I think so many people spend so much time on their phone and behind a keyboard that they forget how to interact with people, right? So I think if you learn some basic people skills and you treat people the way you'd want to be treated, I think you're generally going to be okay. And part of that requires you to read the room. You can't read the room behind a keyboard or behind a monitor, right?
Well, let's take it kind of, so let's say you're out and you're talking and one person is complaining to the other about their kind of love life. Maybe the other one says, well, I really like that. And, obviously, I think when you say it starts to build it up, if somebody takes that and grabs their phone and thinks that's a reason to like do what unfortunately teenagers and stuff do, take an inappropriate picture and send it to them, obviously that rises to the level of harassment. Hold on. But we've all seen those cases where they use that opening to start kind of nibbling away, like my workplace has become a dating app, into where I'm now coming in. So how was your weekend? What happens in your life? But really it's some weird warped way they're trying to go around and land a date at the work site.
But I'm going to take a more conservative view on this than probably you would. I think that as an employer, and frankly, I represent mostly employers. You represent employers, employees. You primarily represent employees. Absolutely. So in representing employers, I will see the cases that I have seen that have led to a lawsuit. We had a case over in Ohio that started with what I would call banter. Okay, salespeople were in another remote location, males and females, because we all obviously have a lot of, all workplaces now are diverse in every way, that they were at a remote location and there was just banter. I would call it banter, relationship banter. And the relationship banter continued to alcohol, right? A lot of alcohol, more relationship banter. And then it became kind of a contest and a little bit of a competition saying, hey, I bet you couldn't hook up with that person. I bet you couldn't hook up with that person. It just kept kind of continuing, right? So I'm not sure there was ever any bright line, but what it ended up with then was photo of a manager being sent to all of the employees. Okay, basically a naked picture. This person happened to have a naked picture of their male manager and they were a female, and they sent it to all the employees. Well, that then became a line that was crossed, okay? So in this particular case, that person gets terminated, and what is their defense going to be, right? Now they're attacking the manager, saying, now wait a minute, this manager harassed me by sending me a photo of themselves naked. And I will tell you that it created a large lawsuit. It ended up in federal court. We ended up getting it dismissed on behalf of the employer. But to your point, banter kind of moved its way into inappropriate behavior that kind of moved its way into a lawsuit. So I think as an employer, we have to probably nip that banter quickly.
I agree, but the problem is we all know that, standard like, is the person offended or not? There's some people that we've all had cases either defending them or plaintiffs where they didn't mind getting in the mud. They were inappropriate, but nobody was offended. But ironically, you become offended when miraculously you're being terminated.
Well, but let's talk about offense, because I think we actually have some interesting offense cases in this office, and we have dealt with some.
Not that our office is offended.
No. Using the N-word.
Yeah.
And we have a case right now that's on appeal, because I think even amongst the judiciary there could be a difference of opinion as to whether the N-word is offensive.
I don't think anybody's going to.
I don't think they dispute it's offensive. They argue they think they got to determine some form of intent or something.
Well, let's still go through it. My point is, though, is again, when we get into this slippery slope of subjectivity of what is offensive and what's not, we have a case involving the N-word.
And not to play lawyer on you, but there's a difference between offense, something that's offensive, and something that creates a hostile work environment,
That's
right?
why you are the expert in this area, Tony.
And so the offense, I don't think anybody's going to stand up here and say using the N-word's not offensive, right? I mean, anybody with,
unless it's
half a
rap
brain,
song.
and I apologize to anybody who uses that word, but if you got half a brain, don't use that word.
Right, I would agree. In the employment setting, I would agree.
Absolutely, and even in a social employment setting.
Sure.
It's just, frankly, you shouldn't use it, period. But be that as it may, I think what happened in that particular case that you're talking about is just the judge determined that saying that word a couple of times doesn't get to that level of hostile work environment. Now that's, obviously I don't think there's ever a time when you should be using that word, and I would encourage any employer that is aware of that to take that pretty seriously. That's just, it's bizarro world when people are saying that doesn't create some hostility.
Well, I'll give you though a different example. Are there certain words that how in the world is the public to know they're offensive? I have a gentleman I'm representing, and in fact, the General Assembly's even tried to change laws to prevent this kind of application, but a young staff attorney in Kentucky decided that somebody telling two students to stay out of each other's Kool-Aid somehow implicated LGBTQ issues.
Wow. Wouldn't
For
have
which
seen that one
I
coming.
pulled a video of Cory Booker in 2019 or
No,
20.
wait, for those of us who aren't that smart, who's Cory Booker?
Cory Booker running in the Democratic primary against
Okay.
Joe Biden. I guess Biden tried to claim an issue Cory was. And Cory Booker says to then candidate Joe Biden, stay out of my Kool-Aid. So I send this to them and say, I don't know how anybody would know the term Kool-Aid. First of all, I don't even think you're right. They still are doubling down and trying to have
So
a
are we talking like Kool-Aid, like the trademarked Kool-Aid, like the little man that's sitting there
It's
with the
spelled
smile?
Kool. It's apparently a term that people will say, stay out of my Kool-Aid. I don't know where it comes from, but I can find no nexus to LGBTQ suicide rates and all that. But that's what, so somebody's being faced with employment type issues for a statement saying that he should have known it was LGBTQ, but really what it boils down to is kids started laughing because somebody used the term Kool-Aid. Well, if that's the standard for offense or something, my kids say because I was born in 1972, half the crap I say in life is goofy and arguably offensive.
Well, God help us if they hold us to Kool-Aid, because at 50 years old, I'd never heard that used as or considered an offensive term.
Well, the Department of Education in Kentucky thinks that the term Kool-Aid is LGBTQ related.
Is there some list that we can look? Is there some
That's one of my
statute that-
arguments. We need to. I think certain words. I don't think you need to be put in a big book of offensive words.
That's
But certainly that one. If this is the road we're going to go down, we need to build said book or write said book.
I think you're probably right. But at the end of the day, I don't think, Kool-Aid typically, even if somebody finds it offensive, probably isn't going to be your death as an employer or shouldn't be as an employee. Because I think, again, if you use it once and somebody says, hey, I really don't appreciate you using Kool-Aid, well, then wise up and stop using Kool-Aid. Come up with it. Start using Tang. Oh, gosh, now I really dated myself.
Well,
That's the orange version.
That's right.
well, one thing that I know you and I talked about, Tony, and I was actually shocked when you told me this, that Kentucky has a Pregnancy Protection Act that affords really, really great protections to prospective mothers. And I guess kind of to bring it a little full circle, like, we all watched the recent presidential race and saw those train wrecks of debates, whether you were on one side or the other. But the one thing that I found telling was during the vice president debate, both Vance and Walz, I almost thought they were going to end the debate and say, wait a minute, these two are $1,000 apart on a pregnancy assistance package. That it does seem to be that and you and I talked about it. I know in Japan they have a shortage of, they're not reproducing enough kids to provide for the people they have down the road as they get older and all. That I do believe there seems to be across the board sentiment to protect and encourage people to want to have a family and all that. So if you would, just kind of, what are some of the big highlights? Like the Kentucky, and who would have thought Kentucky has a dynamic Pregnancy Protection Act?
Yeah, actually, Kentucky adopted their Pregnancy Act ahead of the federal act that was just adopted this year. And frankly, it's one of the strongest laws that I can think of in terms of protecting employees.
Before you go into it, I think this is really critical because we get a lot of questions from employers that have one employee versus employers that have 50. Is this something that applies to every employer in Kentucky?
Pregnancy worker? Yes.
No employee limit. It's
No.
That's what I mean. So
Wow.
every employer.
hell.
No.
We got to qualify with it.
That's right. No, and it's absolutely, it's a wonderful law to protect pregnant women. It could even protect women who are planning to become pregnant or attempting to become pregnant. It is an absolutely wonderful law for the protection of women. But on the flip side, it's interesting because of new laws that are so strongly in favor of pregnancy, I think right now, if you were a woman that was 4 to 5 months pregnant trying to get a job, God help you, because with these laws
So
in
is
place,
there discrimination in not hiring somebody who's pregnant?
there is absolutely discrimination in that. But if you get 100 applications and you just don't happen the one pregnant woman and you don't hire the other 98 people, who's going to be able to narrow that down and prove that it was the pregnancy that caused her not to get that job?
When they can clearly see you're pregnant. So,
That's
if I got a
what-
bad
oh.
back and a disability that way, I can hide it.
Absolutely.
If I'm 4 or 5 months pregnant, they're probably not gonna hide that.
If you're looking for work and you're pregnant, I'm saying right now, you got to hide that thing the best of your ability. But on the flip side of that, the moment you're hired, tell everybody. Let everybody know you're pregnant as soon as you're comfortable letting people know, because at that point, you have protections in place. You know what? If you have to go to a doctor's appointment, you get to go to that doctor's appointment. If you have to take a day off because you're having morning sickness, you get the day off for morning sickness, as I interpret that law.
Do employers have to pay for that?
No. I don't think any of this stuff's paid leave, but they have to give you that accommodation.
So it would
to
be
give you the
leave
time.
beyond the normal leave.
Correct.
Now, as far as FMLA leave, after you have that child, that is geared on the amount of employees you have.
That absolutely, yeah. You have to have over 50 employees, and it has to be within a certain geographic scope. But yeah, so in FMLA leave, you don't qualify until you've been there for a year, and it's limited to 12 weeks. So there's a lot more limitations with FMLA. But
So again, to educate both employers and employees on this issue, because it's obviously a real issue. I mean, all of us at one time were children of a pregnant mother.
that's right.
Right? So
Unless it was some type of biblical birth, I
Well,
don't think there's any way around that.
that's another conversation for another day. We'll bring an expert in on that. Maybe someone from the Ark. But practically speaking, so I as an employer would have to accommodate their doctor's visits. I would have to accommodate times that they are sick. What other accommodations would I have to make?
I would say even if it's somebody who's trying to, like I said before, even if you're trying to get pregnant and you have a doctor's appointment for fertilization or whatever else, I think you have to accommodate that as well. I think the law is going to be, and again, let's be real clear. This is a brand new law. The federal law is brand new.
That's right.
So it hasn't been litigated and it hasn't been carved apart by judges and lawyers. So we'll see how
But
it ultimately
doesn't it-
comes out.
What if I'm ovulating during the middle of the workday and I need to do my thing because that's my prime time to get pregnant? Do they got to accommodate that?
I wouldn't ask the employee if they are, because I think that might
That's
be
going to
crossing
rise to a
that.
harassment
That's-
suit then.
Yeah.
No, that's right. But I think, yeah, I mean, in terms of that sort of thing, I think you've just got to be open to the possibility of maybe allowing someone to
Yeah.
take advantage
So, but,
of that. I don't know.
but doesn't this all go back to what you said early on? A lot of this is common sense, right? If we all act reasonable and we all kind of just, I mean, generally if you act reasonable, you're probably not opening yourself up to a lawsuit.
I take it all back to the golden rule, right? Do unto others as you'd have done unto you.
Sure.
If you can treat people the way you'd want to be treated, I think you're probably going to be okay. Now, there are sensitive people in this world, and that goes back to your conversation earlier about some of the phone calls we get. Some people are, angry and upset, and they're never going to feel like you've treated them fairly, and there's probably nothing you can do to make those folks happy. But in the eyes of the law, I think if you treat people the way you'd want to be treated, I think you're probably going to be okay.
You know the problem with the golden rule? It puts all of us out of work. If everybody did the golden rule, we wouldn't be here
Well-
doing what we do.
Well, there'd still be a few wills and deeds.
You're
That-
probably
that-
right, Brandon. But as we well know,
Maybe you
not
don't even need a
everybody-
will. If everyone followed the golden rule, people would just know who was the rightful entitled heir.
Right.
I like that. No, I don't like that. I
So
don't care
so
about
let's pivot to kind of one last thing. I've gotten you've gotten calls. We've dealt with employers who have this. Maybe you're an employer that sells a certain product, and your employee Saturday night gets on their Facebook, Twitter, X, True Social, whatever the hell other platforms are out there, and basically starts foaming at the mouth, blasting, doing this, that, and the other, and lo and behold, shows up Monday. They're told they're fired. They then see an ad at Gatlin Voelker. They call us and they tell us, I had a First Amendment right to express myself after 4 glasses of wine, 11:30 on a Saturday night. I was allowed to call my employer company pond scum. And I've been discriminated against under my First Amendment rights. I want to sue. Why can't they sue? It's a First Amendment, damn it.
They do have a First Amendment right. You're absolutely right. They will not be thrown in jail for making that comment.
Maybe
They-
Facebook jail.
That's right.
Facebook
Maybe-
jail. I just shared filing a lawsuit for a
Yeah.
governmental client.
I think
got
the
banned.
fact that you've sworn 5 times this video is not going to make it on Facebook without some serious editing. So keep going.
But no, I think, yes. No, First Amendment issues do not protect your job unless you're a government employee, right? So if you are in the public or in the private sector and you are employed and the employer hears you calling them pawn scum or their product pawn scum, I think you might want to start looking for jobs.
Well, it's. I would say it's even simpler than that. Unless there is a contract or you are protected or some protected class, you're an at-will employee.
That's right.
So I could just fire someone because I didn't like their Facebook post. Now, so long as I was not discriminating against them because of race, color, creed, religion,
Gender. Yep.
gender,
Pregnancy.
again, mental health issues, which maybe they would claim, I don't know. I can fire a person. Like, I think that's another misnomer that's out there.
Yeah, it's a shame that really good workers can be fired, but I use, going back to sort of what you say, if somebody walks in and says, Jack, your shirt doesn't match your jacket, you're fired.
And it doesn't.
But you know what?
You know,
I wasn't going there. I wasn't saying that. But,
You honed in on it, Jack.
but no, if somebody
it
were to
fire?
fire you
Thanks
for
so
that,
much. It's busy. We got plan on a grid with red buttons.
hey, coming from the guy that wears gray and black all the time because he has no fashion sense, I think you're doing well.
yeah.
I
You
wear
know,
gray and black.
I can't see real well. I didn't realize this morning that this is black and pink and this is blue, but it's okay. I think I'm bringing my own vibe.
It's like you're having a party today.
Just bringing my own vibe. So I want to bring up one final topic because I think it's become relevant in Cincinnati. It's becoming more relevant in Northern Kentucky. I see it a lot with my employers. I see it a lot in our government clients, and that is the legalization of marijuana in Ohio, right? And you know it when you're like walking across to a Bengals game or walking across to Blink, like you're halfway across that bridge and that odor of marijuana comes and emanates from Ohio. But here in Kentucky on January 1st, we will have legalization of medical marijuana. And, you know, we're getting a lot of questions as to how that's going to impact the workplace. I have my own kind of simple thoughts on that, but I would like your thoughts as to this whole idea of now I have a prescription for medical marijuana. I should be able to enjoy my gummies or smoke my pot at work now.
I think as far as partaking at work, that's probably going to be probably something that's not going to be allowed. Again, with a new law, you never know how it's going to flesh itself out. But what I would say is I don't think you have to let people light up at their desk. And I think the other big issue is going to be with people that are operating heavy machinery or otherwise in a position where someone could be physically harmed by them being, having lost their faculties in some way. So I think that's going to be a big exception to any kind of rules.
No different than alcohol, right? I mean,
But
alcohol is
here's the
legal.
problem. This is the problem with it all. So, obviously, right now, before it was legal, somebody gets in an occupational accident, work, they're drug tested, comes back marijuana, they're probably using that to say no workers' comp, they're using that to say you were smoking weed, you're fired, you're whatever. Now, it's allowed. They have a prescription. And what I see as an issue is, with alcohol, we qualify it. We know, you get behind the wheel, you're an 08, you're DUI.
That's right, there's scientific
So what if you
tests that
smoked a joint on a
determine-
Thursday and the accident's on a Saturday?
I agree that the technology is not caught up because that's a huge problem, right? Because a blood alcohol test is going to be the amount of alcohol that is in your blood at that point in time when they draw it. And we have very clearly defined numbers, no
Right.
doubt. With marijuana, it's a positive or a negative, right? There are certain hair follicle tests and testing that you can get that number, but nobody has identified what that number means, what that level of intoxication is, right? Like there's generally a universal idea that anything over an 02 is some level of a buzz, something over an 04. I mean, I've literally seen the charts at the health department where they they determine, which is why the federal government, you can be an 04 and still work. It's
Right.
crazy, right?
There's agreements with union agreements.
Right.
Certain,
Right. So there's very defined numbers. So it's very easy for that employer to test someone to see if they hit the number. With marijuana, you're right.
And that's where
It's
I
not,
think
we don't have that science
well,
yet.
we've passed, whether you're for or against recreational, medical, or whatever else, the beef I hear from people isn't that they really care if it's legalized or not. It's we never did that part of the aspect. Why?
Well-
When I'm walking through Kenwood Mall and you could smoke, they wouldn't let me walk through the mall with an old fashioned in my hand drinking, but I can walk through clearly like I'm hitting. It's kind of like they need to get the societal norms in line to jive with the recreational or medical
Sure.
marijuana.
I will say though that and not to get too technical or too into the weeds, I don't think that a urine test is ever going to hold up in an employment law situation, because a urine test is what's basically already been metabolized. It's generally how we're testing marijuana right now, and a lot of that has a 2 to 7 day
Dissipation.
there's a technical term. It's the reason we're all lawyers. Don't
We
learn that
couldn't get into
technical-
medical
That's
school,
right.
so.
But there is a half-life or something, I think is the term. If anyone's actually still watching this podcast, videocast, I would love to know what the real technical term is at this point. But my point is it's already gone through your body. It's no longer affecting it. That's how we're testing for marijuana right now. There's no way that would hold up. There's no way.
I agree.
So the only way that you're going to be able to somehow articulate a marijuana claim in the workplace would be a blood test or a hair follicle test. Now, the practical problem with that right now is it's expensive, and it may be a further invasion of privacy that your current employment manuals might not employ.
I think of it, honestly, the marijuana issue, I think of it more of like a disability type of an issue for medicinal marijuana. I think to the extent that you're punishing someone because they're using medicinal marijuana for a clearly established disability, I think that would be unlawful, but but I think that also leaves the door open for finding that people that have to use medicinal marijuana are not qualified to do their job if they can't do it without using the marijuana, right? So if you're not qualified to do your job, you don't have a disability discrimination claim anyway, because you don't meet
But what
that.
about, so let's assume that you operate heavy equipment, and let's say even without medicinal marijuana, your doctor told you shouldn't operate heavy equipment when maybe you're prescribed Percocet. So all of a sudden you get in a bad accident, they find Percocet in your system, they can probably file. But obviously you had a disability, but their view would be you should have known you were under the Percocet made you not able to operate that heavy equipment. So you go back to this marijuana thing, and here's the significance. Under workers' comp in most states, there is a provision that says if you're voluntarily intoxicated, you don't get benefits. So what happens to a heavy equipment operator who gets hurt, and it's like, and they say, we don't owe you anything. You were you took your medicinal marijuana. And they're like, I was prescribed that. I took it the night before. I'm fine. But it's because we have no means of gauging the level in the person.
At the end of the day, though, you're not getting fired because you use Percocet. You're getting fired because you had an accident. You just happen to be using Percocet.
Yeah, but in the workers' comp, you may not even have been at fault. Because in like comp, it's a no-fault system. Sometimes bad stuff just happens. Or better yet, let's take a school bus driver doing something fine, and let's say another car hits them under DOT. They still you don't have to be the at-fault driver to still have to submit to find out if you're under the influence of anything. So I mean, I guess my point is I think we're all in agreement. They need to come up with standards, because I think you're going to see this more and more. I was sitting at a Wendy's drive-through the other day, and the car behind me had such a smell of weed coming. I mean, I was in a vehicle, and I could smell the weed. So, I mean, I don't think it's going away. And I mean, they've passed policies in like our schools. Schools were having to decide how they were going to handle medicinal marijuana, if you're going to allow it, prescriptions with kids. So that would infer a school district having to prescribe medicinal marijuana to a child. So obviously there are medical persons that believe that a certain level of it does not make you impaired. Just like some people can have pain pills, still operate heavy equipment. Some people cannot. I mean, I don't know. I don't think any of us have the answer how they're going to figure this out.
Any parting shots about any of these topics or anything else that's out there? Any final thing you want to tell people?
No, I think I'll go back to the golden rule, man. Just be nice to people, treat people the way you want to be treated, and you know what, and everybody will be fine. But
Other than us as lawyers, we'll starve.
that's right. Well, I was going to say, but as us lawyers know, is that we could say that forever, and it's still
That's right.
not going to
That's
not going to take effect because
That's
people
right.
are going to people are people.
How about you, Brandon? Any final
I just
comments?
want the audience to know that we were joined today in order to try and get our technology right. We reached out to Jack's 20-year-old daughter, who, when he thought he would enlighten her about our program, she informed him that she's known how to use it for many a year. And so we want to give thanks to Emma, who's been working the cameras, set everything up since last week. We weren't smart enough to turn microphones on after we failed to record initially. So it should be pretty smooth this week because we got a 20-year-old at the helm of running this
That
operation.
knows what the heck they're doing.
And you are 20, right?
Yeah.
I didn't think you turned 21 yet.
No, not yet.
So we had to go with a younger generation to technology figure this out.
And that's a great segue to our next podcast, videocast, to kind of keep the youth movement going and to kind of keep, this is the holidays, so we're focusing on family, we're focusing on some different things. The schedule is going to be a little weird. Next Monday at 5 o'clock, we are going live. It'll be our first live feed of a podcast videocast, and we are going to have my son, Jack Gatlin, on, and Emma's significant other, Jackson Belk, on. Jackson Belk is a football player at Thomas More. Jack just finished his high school football season at Ryle. They want to talk about football. They want to talk about the playoffs. They want to get back into the NIL discussion. They felt that Sebastian, Brandon, and I did not even come close to identifying all the NIL issues that are out there. They also want to talk about marijuana with the NCAA, that it no longer is a banned substance for the NCAA, and just other things about injuries and how that has been dealt with in their careers as well as recruiting. So it's a football-focused show live Monday with Jackson Belk and Jack Riley Gatlin. And I'll leave you all with that. If you have any ideas for shows, we're always looking for ideas. As we go into probably the next series of podcasts after Christmas, we're going to get on site a little bit more. We're going to talk to a former prosecutor early in January and kind of move around a little bit. Thank you all for listening to Beyond the Bar with Jack and Brandon, and thank you, Tony, for joining us today, and thank you for everything you do, not only in this office, but also for my golf game. You are a great member guest partner, and we are going to win next.